Well, I used to walk up here every morning, and in the afternoon I'm back home again. No more. That's where I used to work on there, Unit 1.
Meet Janette. She was dismissed from her place of employment following anonymous accusations of misconduct made by an ex-employee. She brought a claim for an unfair dismissal against the Federation of Jewish Services to an employment tribunal. Despite the tribunal's serious concerns over Heathlands' use of anonymous witnesses and their failure to provide Janette with necessary time and documentation in order for her to prepare a defence, the tribunal nevertheless dismissed her claim, accepted Heathlands' version of events, stating that during the internal investigation she had already admitted a significant part of the allegations against her. When Janette's claim was made to the Employment Tribunal, both parties received what are known as case management orders. This included a strict timetable ordering important actions to be carried out by specific dates. Heathlands failed to comply with every deadline issued by the Employment Tribunal. The resulting delays seriously affected the preparation of Janette's case and the presentation of vital evidence concerning the internal investigation.
I was told I could appeal, but when I found out how much it would cost me, in the end I decided I couldn't do it. I worked at Heathlands for 13 years and just about to finish my NVQ3 level. They branded me a bully and a racist and accused me of being abusive towards the residents, and I could never work in the care home again. I felt really low, depressed, like I felt I was headed for a breakdown. It's very tearful all the time.
You do not have to be guilty of an accusation in order to be dismissed from your place of work. All your employer has to show is that they believed in your guilt at the time of the dismissal. And that belief must be based upon an adequate and reasonable internal investigation. And case law further instructs that the more serious the allegations and the consequences on the employee, the more thorough and detailed that internal investigation must be.
I have been looking for work, not very successful. I have had a couple of part-time jobs temporarily. I couldn't afford legal representations, but I had a friend been in Hollingshead who has helped people in employment laws. He told me he didn't have no experience in the tribunal laws, but he said he would help me as best as he could. He worked hard on the case, but it was difficult because of all the delays caused by Heathlands.
In Janette's case, we urgently needed to clarify and verify a number of very important discrepancies from the internal investigation. Our first lawful attempt at approaching a potential witness was met with a letter from Joanne Ingber, the HR officer of the Federation of Jewish Services, who was also one of the managers involved with the internal investigation. The letter stated that I, as Janette's representative for the tribunal, must not approach anyone employed by the Federation of Jewish Services.
We needed to talk to witnesses, but Heathlands refused Billy to talk to anyone.
The record notes your instructions that I must not communicate with employees of the Federation of Jewish Services. You are aware that this obstructs the collating of evidence vital in this Taylor's case. Serious restrictions shall be addressed at the appropriate stage of the tribunal process. In order to clarify certain issues, it will be necessary to interview a number of witnesses involved in this matter before pursuing further action on this matter. Joanne Ingber later attempted to justify this matter in a statement to the tribunal, saying that I had contacted a family member of one of the witnesses, which had caused them great distress. She invoked her duty of care towards witnesses who make statements, and so forbid me to communicate with any employees involved with the internal investigation. Now, to imply that I had contacted an innocent family member of one of the witnesses and therefore having to safeguard them from me was quite a damning picture to paint against my integrity in dealing with such sensitive matters, and simply to justify the fact that she did not want me, as Janette's representative for the tribunal, to question anybody involved with the internal investigation. However, let's take a closer look at what she actually knew about this so-called family member at the time and decided to leave out of that statement to the tribunal. Joanne Ingber was aware that this family member was in fact a recent employee of the Federation of Jewish Services. She was also fully aware that the reason I had contacted this ex-employee was because he had made the foulest of allegations against Janette, which had been placed into a witness statement by one of his relatives, a current employee, and which Joanne Ingber had included in her investigation against Janette.
It was so unfair because we couldn't get to the witnesses we needed to talk to, and they had all the access to the witnesses that they could talk to, while we had none.
For instance, I queried an accusation of gross misconduct made against Janette by the disciplinary officer, which was totally contrary to the documentation. They immediately secured a witness statement written in their favour from one of their freely available witnesses and entered this into the documents for the tribunal. I requested disclosure of vital documentation showing possible personal grudges behind the anonymous allegations. They refused to disclose the documents and instead substituted this request with another witness statement in their favour for the tribunal. With such little time left and only a skeleton of a case prepared, I reluctantly informed the tribunal of Joanne Ingber's refusal to allow access to witnesses and of her refusal to identify two key witnesses involved in this matter, as we shall see in a few moments. I then received an unusual communication from her stating that I would hear in due course.
We didn't know at the time what they'd done. They called in their solicitors.
Their legal representatives were now to override Joanne Ingber's instructions to me and stated that I did, in fact, have the right to speak to any witnesses I wished. The Federation of Jewish Services had interfered with my lawful activities in gathering substantiating evidence for legal proceedings. As the Federation had already cost me 3 months of case preparation time in this matter, I was now hoping, at the very least, to get some kind of cooperation. This was not to be the case. Their legal representatives advised the Federation that they were under no legal obligation whatsoever to allow me access to witnesses at their place of work. They further advised them that they had no legal obligation to assist me with any witness contact details, essentially making interviews inside or outside the workplace impossible.
Well, the only way we can contact witnesses was to wait outside work all day, but we didn't have enough time.
When Janette entered that courtroom, she had no witnesses, not even a basic written statement to verify her version of events. The exchange of documents is a simple process where each side requests from the other the documents they will need to prepare their cases. The tribunal itself says disclosure of documents is not a hostile process. It requires cooperation so as to ensure that the case is ready for hearing. The experience I was about to have with the Federation was to be quite the contrary. The main thrust of the claim against the Federation at the Employment Tribunal was that their internal investigation had been shallow and one-sided, and that pseudo-confessions had been extracted from Janette by the way they had summarised the anonymous witness statements against her. And as the case unfolded, it became quite clear that essential documents existed that substantiated Janette's version of events, and we were lawfully entitled to request these documents. I was finally in a position to request disclosure of the original letter of anonymous allegations made against Janette, which the Federation had kept from her. As we read through it, we were to make some astonishing discoveries. The originator of the allegations, now confirmed as a Mr. Martin Ighodaro, had not just made allegations against Janette, but against 3 named members of staff. On closer inspection, Janette noticed that these members of staff had previously had cause to complain and report Mr. Ighodaro's own alleged incompetence and attitude towards staff and residents on the unit.
This is the first time I've ever heard of this, that Martin made an allegation against me and other members of staff. In fact, we all made a complaint about his behaviour and we even documented it into the key workers' input.
Here was clear evidence of potential grudges which case law requires should be investigated whenever anonymous witnesses are used. An accused person has the right to know the identities of accusers in order for them to respond properly to allegations put against them. And this is so fundamental to natural justice that it can only be waived in exceptional circumstances where genuine threats of intimidation or reprisals against witnesses exist. And of course, no such threats existed in this case. In fact, there were no legal nor moral grounds whatsoever to justify the outrageous use of 8 anonymous witnesses against Janette. This served no purpose other than to make it as difficult as possible for her to answer any of the allegations made against her. We were also to discover from Mr. Ighodaro's original letter that he claimed at least 2 unnamed senior members of staff had actually witnessed his allegations. Here were 2 key witnesses, and as Janette's representative for the tribunal, I needed to speak to these people. My repeated requests to have these 2 key witnesses identified for questioning were completely and utterly ignored by the Federation of Jewish Services. Now, I don't know why there was such resistance to this request, but it might have something to do with the fact that Mr. Ighodaro had also brought allegations of gross misconduct against them. The Federation were to maintain that these multiple allegations made by one person against multiple members of staff, including my client Janette, had nothing at all to do with her case. I disagreed most strongly. I requested copies of the written complaints made against Mr. Ighodaro by the members of staff he was later to bring allegations against. I also requested the background information and interviews surrounding the multiple allegations he had made against all these members of staff, and identification of the 2 key definitive witnesses that Mr. Ighodaro had claimed witnessed his allegations. The Federation, already refusing me access to witnesses involved with the internal investigation, were now to refuse to disclose the documentation. Instead, they substituted this request with a witness statement written in their favour. But it wasn't to end there. Joanne Ingber, the HR officer, was to state the following: due to confidentiality and data protection, we are unable to provide the requested documents.
We were always told that key workers' input were always used in investigations and in legal procedures.
As these documents were vital, I decided to check Joanne Ingber's claim with the Data Protection Agency. The excuse Joanne Ingber had given me to justify her refusal was incorrect. The documents were in fact exempt under Section 35 2A of the Data Protection Act, where information is necessary in connection with legal proceedings. After further unsuccessful attempts to secure these documents, and with no more time to accommodate further delays, I made an application for a court order to disclose the necessary documents. Their legal representatives, who had now become involved with the case, were again to override Joanne Ingber's decision and decided to disclose the written complaints recorded by staff against Mr. Ighodaro. Eventually, they were to reluctantly disclose the remaining requested documents, but claimed to the tribunal that I was on a fishing expedition for information. Now, a fishing expedition in this context is when someone asks willy-nilly for documentation in the hope that they'll find something that they can use. This accusation was made against me despite the fact that I had asked for specific documents for specific reasons. By this time, I was getting used to being accused of something or other every time I attempted to get information about this internal investigation. But what I was not getting used to were the serious delays they were causing to our case preparation. When we finally secured the required documents, we discovered vital contradictions in Mr. Ighodaro's allegations against Janette. We found information substantiating Janette's claims about the serious problems staff were having with Mr. Ighodaro, including crucial evidence regarding his alleged abuse of residents, which the Federation knew about but decided to leave out at the tribunal when summarising his allegations against another member of staff. The documents also revealed references to the key witnesses who could have helped Janette's case, but whose existence the Federation had all but denied. Most disturbing of all is that the documents reveal that Janette had been declared responsible for the alleged actions of another accused person, without her knowledge and without even being asked a single question about it. The problem I was facing now was finding enough time to critically analyse all of this late but vital information. They had literally dumped everything upon me at once. By again failing to adhere to the case management orders given by the tribunal, the Federation had cost us 6 weeks of preparation time in respect of the examination of documentation. However, I still had enough put together to show how these anonymous witness statements had been used against Janette to extract these pseudo-confessions. All I needed now was one of those managers involved with the internal investigation on the stand for cross-examination, which was the crux of our case. However, there were now to be 2 more crucial delays which were to cost us the case completely. The case management orders instructed that witness statements be prepared and exchanged by both parties. These play an important part in the cross-examination of witnesses, and for this reason the tribunal instructed that they must be exchanged no later than 4 weeks before the hearing. The Federation had offered no cooperation with access to witnesses and failed to identify key witnesses we needed to question, so we had to rely totally on documented evidence. And I was anxious to study the witness statements from the internal investigation managers. On the very day the witness statements were to be exchanged, the Federation instead decided, for whatever reason and so late in the day, to place the case into the hands of legal representatives. I then received a request from their legal representatives for a postponement of the exchange of witness statements for another 2 weeks to enable them to receive instructions from the Federation. Now, if Janette had been legally represented, we don't know how this matter would have been handled. As it was, we had no option but to agree to yet another delay, which was to cost us another 2 weeks of case preparation time. At the end of the day, the Federation had not produced witness statements as instructed by the tribunal. So what could we do? Certainly disagreeing with this was not going to pluck them out of the air. Just 2 weeks before the hearing, we finally exchanged witness statements. We were shocked that the only witness statement they had prepared was for a Karen Johnson, the disciplinary officer. There was nothing from the internal investigation managers. I sent an immediate email asking if this was the only witness statement forthcoming. I waited for a reply. I waited and I waited. In the meantime, I studied Karen Johnson's late witness statement and worked every spare hour I had preparing the questions for her cross-examination. After 5 days and failing to respond to my email, I contacted them again, requesting an answer to our question. They replied, "Apologies for the delay. Karen Johnson is the only witness for the respondent." In desperation, I asked if Joanne Ingber was prepared to appear voluntarily at the tribunal for cross-examination. Our case depended on this. They told us she would not be giving evidence. They had decided that none of the managers involved with the internal investigation were to give evidence nor be available for cross-examination. But the bombshells for us were still not to end there. Just days before the hearing, we were informed that they were now to make alterations to Karen Johnson's witness statement. Apparently, after reading Janette's witness statement, they felt there was a need for further expansion and clarification of certain issues. Although there was no substantial change to the contents, they nevertheless deleted parts of statements, reworded existing parts, and changed paragraph numbers that I had painstakingly referenced for cross-examination. Now, with all the pressures already upon us, I now had to go through this whole process all over again. And to be honest, I did not have enough time to complete it. And I had to sacrifice a lot of the subtle issues that I intended to raise. I was not a happy man. Despite all these setbacks, I was able to establish that Karen Johnson hadn't followed ACAS code recommendations regarding disciplinary procedures. Here, in order for an employee to prepare their case, they should be provided with copies of any written evidence, including witness statements, in advance. In fact, Karen Johnson was to admit on the stand that she was not familiar with the ACAS code. She apparently was also not familiar with her own company policies, which clearly state that copies of any documents to be referred to will be issued in advance. Instead, Karen Johnson arbitrarily gave Janette specific written instructions to come in 30 minutes before her disciplinary to peruse the documentation. The Federation were to claim that Janette was given sufficient time to study the documents.
They asked me if I read all the documents. I said yeah, but I didn't understand. There was lots of papers. All the names were Tipexed out. I didn't know what to do.
Janette had a fundamental right to prepare a defence, particularly in view of the serious allegations that had been made against her. Already struggling with writing and articulation problems, Janette was expected to study numerous anonymous witness statements, analyse the complex minutes of an investigation meeting, and prepare a defence, all in 30 minutes. When I referred to this crucial paragraph at the tribunal, it had gone missing from the letter the Federation presented in evidence. Fortunately, I had the original letter in a separate folder and we were able to restore the missing paragraph. It is also curious that Janette's union representative, who would have been familiar with the ACAS code and company policies, raised no objections whatsoever as to how the disciplinary meeting was conducted. Even Janette's desperate plea during that meeting that she did not know what was going on because she didn't know who had accused her went unheard, not only by the Federation, but also by her union representative. Fortunately, the person who was taking notes of the meeting didn't ignore it and was prudent enough to make sure it was recorded in the minutes. Now, although most of the disciplinary procedural errors were acknowledged by the tribunal, they were not held to account. And this is because the tribunal accepted the unchallenged version of events that Janette had confessed to the allegations. Even answers Janette gave at the tribunal could not be understood without understanding how the confessions came about. Now, everyone believes that Janette and the Federation entered the tribunal on an even footing and that all the evidence was fairly presented and fairly heard. And this is why it's essential that people understand exactly what went on behind the tribunal preparations. We discovered afterwards that we could have presented a case for all the disadvantages the delays had caused to us, but we didn't know this at the time. We're not lawyers. All we knew is that the tribunal gave us case management orders and that the Federation had failed to abide by them. This is the evidence that I brought to the court. And this is the only part that was heard, the cross-examination of Karen Johnson. And even this was compromised because of all the late alterations to an already late witness statement. In the next part of this documentary, I will be presenting the unheard evidence concerning the internal investigation. Here, I don't have to concern myself with delays caused by the Federation. Here, I don't have to concern myself with my lack of legal and procedural knowledge in conducting tribunal cases. Here, I can show how an apparent open and shut case, complete with confessions, is not as open and shut as at first it might appear. The path of the law is strewn with examples of open and shut cases where unanswerable charges which, in the event, were completely answered, of inexplicable conduct which was fully explained, of fixed and unalterable determinations that by discussion suffered a change.
I am staying positive, but it's hard. The things I'm doing at the moment is doing my photography, which I love, and also playing the guitar.